everyone. Thanks for joining. Hope you all are doing good. I'll start with my introduction. I'm Ankit Sharma, and today, we'll be discussing on the much-awaited DPDP Act. So, it's a landmark legislation shaping India's digital ecosystem, emphasizing on data privacy, user rights, right, and how going forward we are going to work with the foreign entities. So, in today's session, we will be exploring its implications across various sectors and its alignments with the global trends. So, along with our esteemed panel, so today we have some very, big names in our panel. I'll start with Lieutenant General Rajesh Pant, who was, former National Cybersecurity Coordinator, PM Office, and Chairman, CSAI. Mr. Sumnesh Joshi, Deputy Director General, Ministry of Communication. Mr. Rakesh Maheshwari, former Senior Director, Cyber Law and Data Governance in Ministry of Electronics and Information Technology, and Puneet Bhasin, who is a well-known cyber law expert and founder of CyberJor Legal Consulting. I am, as a bit of introduction about myself. I am a Senior Director and a Head of Solution Engineering in Cyber. So with this, I'll not waste much time, and I will directly jump onto the discussion, and we'll start our session with a question to Mr. Pant. Sir, as you know, you have worked on some esteemed profiles. You have worked as a national cybersecurity coordinator, right? And you have I know we all know that you have also gone through a lot of global compliances and everything. So how does DPDP Act align with our global data protection framework, like a GDPR or a CCPA? And most importantly, how does this act align with India's ambition to become a global data economy leader?
Thank you, Ankit, for that question, and good evening to my fellow panelists and to all the listeners. I'm trying to see the number here. So, Ankit, you said much awaited
Yeah.
act. It is really a much awaited act. Let me, start off the story a little bit from 2017, when Justice Kuppuswamy and versus Union of India case took place, and privacy was declared as a fundamental right under Article 21 of the Constitution. And if you read the Constitution, the moment uh, something becomes a fundamental right, then it becomes incumbent on the government to ensure that it is provided to the citizens. You see, democracy is all about empowering the citizens. So then immediately, the government had appointed Justice Shri Krishna to make a draft, and he did an excellent job. Let me tell you, it took about a year or something. It went on to the public comments, and then when it came back to the government, somebody suggested that why only personal data? Why not include the non-personal data also in that? So again, it went through a cycle where Chris Gopalakrishnan of Infosys was the lead in that particular task force, and then they came back with the draft. And finally, around early 2022, when the draft was seen, it was found that there were a large number of amendments, and very rightly so. Both the Minister of State and the Central Minister, presently also he's there, Shri Vaishnav. They say that we are introducing a bill in Parliament with so many amendments, it doesn't look good. So fresh bill was drafted, and Rakesh has played a very major role in that. And finally, of course, on 11th of August, it was published as a gazette, and it will become operational as notified for the different sections. I mean, that is the way it goes. And till that time, the SPDI rules, as they are called, Section 43A, I think. So SPDI is that, sensitive and that data, protected data. That will continue to be in force. So with that as a background, what you asked me is how does it align with the global rules? So globally, we had two major models in front of us. One, of course, was the GDPR. Everyone is aware of the GDPR. It is applying in all the EU countries, and GDPR was region centric. So entire EU was covered with that. Whereas what we found in the US was that it was sector specific. So if you see CCPA, if you see some of the other rules, they were set. So these two big models were there. I think in the wisdom, the government decided to go the GDPR route, and by and large, you'll find that it is modeled on the lines of a GDPR, but it is Indian centric. And some people ask me that world over we are calling the individual as a data subject. Why have we called it as a principal? Now that is the beauty of the Indian democracy. A data subject, and I'm being very very simplistic here. That there is a king and there are the subjects, right? Whereas in Indian democracy, we treat the citizen as the king, right? So we have made him the principal, and the law revolves around him. So that is the difference. On the world over, they are saying data subject, but we say no, he's the principal. World over, they are saying controller. The word used is controller in GDPR, but we are saying no, that's a fiduciary, and fiduciary has a certain sense. It's actually derived from the financial side of things, but it has a sense of trust. So between the principal and the fiduciary, there's a sense of trust, and of course, there's the processor at the back end. So it does, model. It is modeled around the GDPR. And as far as your last part of the question is concerned, uh, you see today with the digital public infrastructure that the government has created in almost all the sectors. It's not only Aadhaar. You take financial sector, agriculture, education, everywhere. It is nationwide. I mean, at scale, the Digital India program is being launched. So wherever there is such large amount of data, which includes the personal data of individuals, that has to be protected because what are the hackers doing? The hackers, the first thing they do is they do credential grabbing. They are stealing the credentials of people and then using them or misusing them, as we say, to con them, etc. And then data has a value. I mean, everybody is being saying that data is a new oil. And I went to one conference, they say data is like a treasure chest. It's only when you open the treasure chest that you come to know, its actual value kya hai. So, and a lot of it, with whatever has happened from the security point of view, it's been taken away. So there are issues of, cross-border free flows and etc. So then how does the government protect the data is very, very important for our national economy. And now with our aim of becoming the third largest in 2030, I think every day I hear a rumor कि आज आ रहा है rules और आज notification आ रहा है. I'm just waiting for that day to come. It is overdue. Frankly, let me tell you, it is overdue now, and it should come. And we need this as of yesterday. Thank you.
Thank you so much, Rajesh sir, for giving your insights. And we all are waiting for this, lot to come very soon. You touched upon a very important thing, trust. Like that the trust that this particular law is going to build between the data principals, data fiduciaries, and in the ecosystem, the privacy ecosystem in the country itself. So my question to Mr. Sumnesh is that there are certain government agencies which are kept out of the scope from this regulation, right? So how are we ensuring, how are we going to ensure that transparency and accountability in state data monitoring to protect citizens' trust? So if you can just touch upon these points.
Yeah, so thank you for inviting me here. See, this law maybe as already Lieutenant Pant has elaborated in detail, and Mr. Maheshwari is also here, who was main contributor. So, lots of discussion. See, sometimes, when this act was passed, people, still the perception is that we are trying to correct that it's going to, disturb the system. But actually, it's going to facilitate the entire system. And there are state agencies and central agencies, right? And some provisions are also there, say where because the government is going to give some benefits, or maybe just like a COVID type situations, or so that we need to use that data for the welfare of the citizen. It's not that we are consuming that data to abuse the system. So therefore, it is a well thought of idea to keep certain agencies, excluded, right? But it doesn't mean that they will not, follow the DPDP Act. For example, in Aadhaar. So see, all these things, when you see the history of all these things, the privacy, it has come from the Aadhaar only. When the Justice Punnuswamy case was fought in the Supreme Court, yeah. So the idea is that there also, an Aadhaar consent is being taken. So agencies have to follow this DPDP Act. It's not that they will not follow, but yeah, in certain circumstances or some agencies can use the data for the welfare of the citizens.
Thank you so much, sir. So I know I'll come to Rakesh sir as well. Rakesh sir, do you want to add something on this since you were involved actively in drafting, this particular law?
Yeah, so good afternoon and thank you very much for giving me this opportunity. I'll just like to say, as far as the privacy laws across the world are concerned, they are focusing on the consents of the users being there. They are focusing on the security of the personal data. They are focusing on the privacy and maybe keeping the children away from or keeping children safe from any hazard that may happen, and also deciding as to how the cross-border data flow should happen. So per se, philosophy of all these data protection acts across the world are the same. The level of penalties can be different. Data classifications can be different. The way the complaints have to be made can be different. Every act talks about the rights of the users because privacy is a fundamental right, at least in India. So per se, everybody is trying to empower the citizen. Everybody is trying to empower the users. Maybe in our case, in DPDP, we have not really talked about the right to portability. Some other laws do talk. But we have, for example, talked about right to nominate. So by and large, the principles on which data protection acts are there are the same. Of course, local nuance, country-specific nuances are different. And particularly in the case of, Indian context, it was not just about protecting the people, but also utilizing the power of data for the growth of the country, for the growth of Digital India program. And to that an extent, the DPDPA is a balance or is having a balanced approach in meeting our requirement of growth as well as protection of people's data. That's it.
Thank you so much, sir. So, you have touched upon a very important point, like, that we are also going to provide a trusted, a label of trusted jurisdiction to certain countries now going forward. When there's going to be a cross-border agreements, cross-border related data processing is going to happen. So my question to Puneet over here is that, Puneet, do you see that with this particular law coming into the picture, India will also be gaining sort of a trusted jurisdiction against the compliances like GDPR, like they have a safe harbor, US have a safe harbor with EU. They provide us a significant data controller kind of a stuff, a label to them, a trusted jurisdiction label to them. Will India be receiving that kind of a thing from the other countries?
Well, I think India already is. So in terms of business growth, and my personal opinion, again, in terms of a lot of business ethics, a lot of things like, India may be undermined, but to a great extent, we have that inbuilt in our culture, in our system. It's not something that, we just require an enforcement to ensure that people are going to comply with the same. And even the Indian apprehension, one thing I will tell you, the whole apprehension that the government is going to misuse your data. Honestly, more data of Indians are like, the most sought after for data, considering our population to be the largest and, the amount of analytics that can be performed on the data. So there are multiple nation state actors which have access to our data. There are multiple huge corporations like Google, etc., Meta, everybody publicly has access to our data. And as a matter of fact, they can misuse it to a way greater extent as compared to what our government can ever do. Our government is an elected democracy, which is elected by the citizens of the country, and the law very specifically stating in case of national disasters, national security, it is in those situations that, without consent, the government agencies can access your data and provide you immediate relief or services, whatever necessary in national interest. So a simple thing, if there is a COVID pandemic and a large number of people are being affected, should the government at that time come and take your consent? Are any of the multinational corporations, even today, despite there being no pandemic, taking your consent? Are nation state actors who are acting against your nation taking your consent for your data? Nobody is. So when we are talking of our own democracy, I think it's very, very important for people not to be blindsided with the wrong narratives which are perpetuated by multiple other agencies acting about this whole concept of mistrust in your government, mistrust in your nation, mistrust in your law. So I won't name any organization, but there were, I'm quite certain, social media platforms which even went up to the Supreme Court, to the High Court, challenging this particular act. On what basis? Today, would they do that in any other developed country where they would say, we are above your law, and say, we are going to come to your Supreme Court and challenge your law, and our law is preceding you? That's not what happens. So I just see all these means as different methods to undermine our national sense of nationality, sense of judicial binding that is there on individuals and organizations, and multiple actors at play with that. So in short, to answer your question, I see this law as a completely a game changer for India, ensuring that India is also on the same platform as other countries which are so-called developed. India, any which case, on the process to that, and also a lot of questions: who decides who's developed and what parameters? That's another angle altogether I will really not go to. But India on that path already, and definitely with the kind of population, with the kind of growth that we are seeing, that's exactly where I think this law is very, very pertinent, considering Indian businesses and other people, other businesses who are dealing with Indian data. That is the most important aspect. If they are touching upon our data, they need to comply with our laws, which till now we have been like an open chest. You do whatever you want with our citizen data, do whatever you want with our national data, and follow your own law of your own country. We have to come and challenge you in your country for everything. So I think this is going to make a major difference in the criminal justice system and the business practices in India, and obviously include individuals having a larger amount of confidence about their fundamental right to their privacy and their data.
Very well explained, Puneet. So, just a follow-up question to you, right? We discussed on the criminal justice and things like that, right? So, any law is as good as its enforcement, right? So, what are your suggestions? What do you foresee that, how India is going to create a robust mechanism to handle complaints effectively and to provide the timely justice to the data principles?
See, the complaints that are there, if filed by a data principal, any which case, there is a body which is going to be the Data Protection Authority, which is dealing with that. Now, when I talk about the criminal justice system, primarily what tends to happen is when there is no Data Protection Act in the country, when it was not there, you need to understand that there was no regulation pertaining to foreign entities handling Indian data. And that also meant that they were always saying that they are completely regulated and bound by only the laws of their own country. Now, for example, today, if a police officer, this is something practically we see on ground happening. Now, when there is an FIR registered, let's say in a police station in Mumbai, over here, the officer requires data in order to, with all the kind of technology available today, perpetrators can be easily traced via their Google locations, via their phone locations, last chat locations, multiple methodologies are there. Now, when it comes to accessing your own nation's citizen data for criminal jurisprudence of your own country, when a police officer approaches, the standard response that comes is kindly get a court order. What does an Indian officer do? Okay, I will go to the local magistrate court. Does that court order suffice? No. The next part that comes from these foreign entities, which are major corporations, is that we are governed by the law of XYZ country. Please obtain an order from a court from this jurisdiction. Now, do you think an investigating officer from Mumbai is ever going to go to XYZ country or arrange to file a case over there in order to obtain that data? So if you would be aware, a lot of these corporations have also been fighting in Indian courts about why should we provide that data, why we should not be keeping it encrypted, why we should not be doing so many things. There are so many things that are going on the legislation part and the litigation part that is going on. So the jurisprudence, the problem that comes is everybody is taking Indian data, saying I'm governed by the law of another country. And unfortunately, the Indian law enforcement, when it comes to trying to bring people to book, is struggling. So here, what the law says is, if you are handling Indian data, you need to have an Indian entity, you need to have Indian presence, you are within the governing law of India. So you touch Indians' data, you are going to be covered by this law, and you are going to answer the jurisdiction of India, the courts of India, and the police of India in order to ensure that there is complete compliance to the law.
Thank you, Puneet, for sharing your views. Obviously, in order to formulate these things, we have to expedite the implementation of this law and compliance as well in our country. So, since Rakesh, sir, you are most closely working with the departments who are actually creating this this act, this law, right? I just want to know from you that what steps government is taking to ensure timely and effective rollout while minimizing the compliance confusions among stakeholders.
Good. So the law already envisages constitution of a data protection board. This data protection board will be coming in place once the rules particularly related to the data protection board, its functioning, its constitution are ruled out. So I assume very shortly the draft rules should get published. Hopefully, once the consultation period is over, as soon as possible, at least the rules relating to the data protection board and its constitution are also, issued, notified through the Gazette, and the process of constitution begins. I do believe that the board is competent enough, is having reasonable capacity to be able to handle the rightful requests and rightful, I'll say, complaints, or maybe rightful instances of breaches which have been reported by the organizations, the data fiduciary as per the Act, to be able to do the inquiry and maybe decide the next course of action, including maybe waiving the complete penalties, maybe asking them to be more vigilant about it, asking them for a penalty, or there is also a provision for alternate dispute resolution. So per se, the law is complete. The law does define all the elements of the expectations from the users, expectation from the data fiduciary, expectations on part of data governance, effective data governance ecosystem. Rest, of course, let's see, when it gets actually rolled out and the way it is implemented has to be seen and can be evaluated only after it's done.
Rajesh Pant, sir, a question to you. With so much the government of India is doing, they are empowering the citizens with so many, things that they can exercise when the data is being misused or something like that. What do you feel that, how should we increase the public awareness, for their digital rights under this law? What can be the best way to do that?
So, firstly, let me clarify that this law is applicable both for the public as well as the private sector. Some people feel, it is only for government departments and things like that. So that should be very clearly specified. Second, let me just go back, and Puneet has made some excellent points, on its impact on national security and the way people are trying to force their way, especially the foreign companies, upon us. And the twist I want to give here is a twist on artificial intelligence. You see, the next big transformation that is taking place is going to be on the AI front. And what does AI need? AI needs data, AI needs compute, and AI needs a large language model. These three things comprise of an AI. And the most important is the data on which that AI functions. And the data of Indians is global data. It is globally considered as the best data. And the reason is because of our variety and our scale. Let me give you a crude example. You take facial data, for example. Now, Indians, we in India, we have, fair skinned, dark skinned, small eyes, large eyes, all shapes and sizes. And the data of Indians represent global data, right? So with a data like that, you can make a very good facial recognition system, and that is how things happen. You based on that training data, the artificial intelligence decisions are made. So there is a great, and the timing is very important because now, globally we are at a cusp of if I may say, a transformation which is based on AI. And the government of India has already come out with Niti Aayog has come out with a paper, METI has come out with some guiding principles. So that AI angle I wanted to give. Now, coming to your aspect of awareness and education, I think it is just like cybersecurity that already, some you find radio advertisements coming and things like that. So I'm sure when the DPDI, the Data Protection Board of India, is constituted, they will have a scheme for education and awareness, which will include, both your print and video, and it is something that will start at a young age. I'm sure in schools curriculum also this will be laid out, and it will be in different languages, all 22 of our official languages. It will be rolled out. So there will be a plan for this education awareness, which is very important, which is for both the sides, because the penalties, as you are aware, go up to 250 crores, and of course there will be a method behind that. There will be a process behind that as to how have you appealed and things like that. So a lot of clarifications actually are required, including those for children, and some discussions are going on. But what you asked about the education awareness, I think my mind straight away goes back to cybersecurity and the way we carried out the ISA program, and now you find in films also the ads have started coming. So similar thing. Last year, let me just share with you, 2023. I think from the legal and jurisdiction point of view of our nation was a path-breaking year. The DPDP Act came out, the Telecom Act came out. It superseded the Indian Telegraph Act of 1885. And then, of course, we had the BNS, which, the IPC. So I think this year and a half has been totally remarkable, and hats off to, people in the government who've decided to, transform the new India and take us towards, our president's, prime minister's dream of Viksit Bharat by 2047. So education and awareness will play a very major role in that. Thank you.
For sure, sir. Education and awareness is going to be the key thing for the coming years in India about the data, the security controls that everybody can exercise. So with that, I also want to discuss with Mr. Sumnesh. Mr. Sumnesh,
Yes.
do you foresee this act fostering trust in India's digital ecosystem and is going to attract more foreign investment?
See, when we are going to implement it, so of course I know lots of compliances are required, and particularly with respect to the security of the data, not from the hardware perspective, from the software perspective, both perspective. And even the Ministry of Communication is also working, and as far as the telcos are concerned, they're the mandatory that they have to use all the trusted devices, so the data should not get leaked, or information will not get leaked. And now we are also suggesting the industry also, so whenever they use any hardware or the software, it has to be the trusted, and they have to ensure the data should not get leaked, because when you take the personal data and maybe the consent you have taken, but if something has leaked, so and hefty penalties are there. So my point is, because of this hefty penalty, it's a totally decriminalized bill, but the aim of the government is not that to earn the money. Aim of the government is that yes, everyone will work in compliance with the DPDP Act, and the resident, the citizen should feel safe that yes, we are sharing the data. And to my mind, many industry player will give the solution to all the companies, because it's a maybe date of effect is yet to be announced, but when we create the awareness about DPDP Act among the industry, we are telling that you go through each and every line of the DPDP and please revisit your architecture, right? And make all the required changes in the hardware and software. And of course, there are many companies are giving the solution. So of course, it will the participation of the company will increase to give these type of solutions. But to my mind, we have to create more and more awareness, and both side, one on the industry side as well as to the consumer side also, that they should not simply just give the data without the consent, because consent is something that we are seeing when we are seeing all the PDS system or Aadhaar system, though there are the Hindi language or English language or the vernacular language. Now as per the act, that yes, the language of the choice as per the Schedule 16 of the Constitution, that has to be provided. So a lot to be done by the industry, So of course the solutions and industry has to come up and provide whatever is written in the act, and make their life simple, because resident or citizen should have a trust that yes, I am giving the consent for this purpose and data is not going to be misused. And they should know that if something has been breached, where to report. So on that, we have to work.
Definitely, Mr. Sumnesh, a very valid point. So, Mr. Rakesh, I also want to ask you, about since we are discussing a lot about the consent, purpose, data minimization, data limitation, things like that, right? It all requires a high level of awareness in the users, in the common Indians, right? So while drafting this thing, the same question which I asked Dr. Mr. Rajesh Pant as well, at what was in the mind of the policy makers, how we are going to roll out the awareness campaigns and things like that for the general public?
Yeah, so there are once again two aspects. One, whether the board is empowered to provide training and awareness, or maybe is having the responsibility of creating the same, or is it the government's job, or maybe it's for the society to take care. The law is already there, it's supposed to be known, and let everybody try to put an effort about it. So on this front, I'll just like to mention that the government, particularly the Ministry of Electronics and IT, has already started carrying out public awareness programs. Lot many have already been done. Next is being done along with Bureau of Indian Standards on 30th of November itself in Mumbai. So I'm sure, such programs will increase in its intensity as well as outreach. Like as General Pant mentioned about the ISEA program, which was with respect to information security, this will be with respect to privacy, but I doubt whether the board will be doing any such activities. Of course, this is one law where there is already a lot of awareness amongst the lawyer communities, amongst the public policy organizations, amongst the think tank, and to that an extent, therefore, the civil society, and to that an extent, there is already a awareness campaign by all of them. But yes, India is a big country. The law does provide consent to be as simple as possible in a language which is understood by the user. Yes, there will be challenges because almost each one of us, not just about India, almost everywhere, people tend to just agree on whatever terms conditions are offered to them. The law has, however, conveyed it clearly. Any consent which is required to be given has to be explicit. That means by default, it is no. So over a period of time, it should pick up. It also depends upon the way the board actually adjudicates the matter. and through the matters which are adjudicated, the kind of awareness which is created by on the social media platforms, on the print media, and maybe on other media of mass communication. So I'll say, let's wait and watch. Provisions are there.
sir.
Provisions are there. Intent is there.
Ankit,
Yes, sir.
I just want to
Yes, sir.
Ankit, I want to add something since
Sure, sir.
I attend a lot of these presentations by cybersecurity companies, and today the concept is that a company provides a total solution, one framework they call it, from the endpoint to the highest, SOC, SOAR and all that. So now when some of the new presentations I'm hearing, they are telling me that they will also put a module for implementation, for compliance of the DPDP Act. You see, the awareness that you're talking of has already reached the other side, the technology developers. And what they're saying is that they will check your system, they will see how much personal data is there, whether the compliances have been taken or not. If it was to be deleted after 3 years, it's going to be deleted. So all those aspects, a module is there, which will be fitted into the existing system that they are offering, right? So this is something really interesting, that on the side of these solution providers, they are ready to come out with this product.
No, definitely, Rajesh sir. So this is something, because, industry started working on this thing, I think 2, 3 years back only, right? The problem is to actually take, to give this kind of a knowledge to a very, very grassroots level. That, every single Indian citizen should know the value of their data, and they should be aware of, the value of consent and the purpose and things like that. And I'm very hopeful that, soon enough, we will be having certain programs like, you mentioned, and Rakesh also mentioned that we are now starting some training, certain things going to be included in the curriculums of the, the young individuals, so that they should start valuing their data. But thanks for this information. Another thing that, Rakesh sir, I also want to ask you, the Act also establishes the Data Protection Board of India, right? So just want to know what is going to be the roles, responsibilities, where is it going to be placed, right? And do you anticipate any challenge in ensuring its independence and effectiveness?
So Data Protection Board is going to be digital in nature. While there will be a secretariat, and secretariat will most likely be in Delhi, but the board will most likely, and in most of the scenario, will act through the digital, or will interact through the digital mode. And so is true with respect to the tribunal, which is TD set in this case, which is the higher appellate body, which also needs to go online, at least for this particular act, because they have other I'll say scope of their work. But for this, they will also be digital in nature while the appeals are heard. So that's one. Second is how exactly the board will be communicated. What will be the composition of the board? As of today, it is to be confirmed through the rules. But yes, there will be a chairman, and hopefully 6 to 7 members shall be there. But depending upon the actual number of, I'll say, grievances, unaddressed grievances, unresolved grievances, the breach being reported by the organizations, referred by the courts, referred by the central government or the state government. That's the means and ways of how the tentacles, the antennas of the Data Protection Board will work. So depending upon how this rolls out, the members can be increased or decreased, at least as per the intent of the law at present. The board, though, shall be appointed by the government. I do believe, and I have a strong conviction, there is no reason to believe that the board will not be independent. Board will be independent, but board has to be competent. Board has to have enough of resources to be able to do the investigation, inquiry, and to be able to reach to the right conclusion at the earliest. Because complexity in the digital world, particularly when you are dealing with multinationals, when you are dealing with data, I mean, being stored, being processed across any jurisdiction, because per se there is no such restriction. So inquiry will always be a challenge. And to that extent, the trust of the people in the effectiveness of the law, once again, will come based on how exactly and how fast and how swiftly, I mean, the board is able to act, and the decisions are in a way honored.
Perfect, sir. We are eagerly waiting for this to get rolled out, right? So, my next question is to Puneet. So, Puneet, there are a lot of debates happening around the topic data localization, right? There is a lobby which says that, it will enhance the national security and sovereignty. Then there is another lobby which says that, it will hamper the foreign investments, or it will increase the operation cost of the business, right? Although now we are providing that level of trusted jurisdiction to certain countries. But I just want to know, like, as a businessman who wants to do any kind of a business in India, how is it going to impact me, right? So I just want to know your views on it.
See, India, initially, the initial versions of the bill, when the act, before it was enacted, the versions of the bill had a more strong tone of data localization. Now, when I read the act which is enacted, honestly, the tone has come down. There is localization. So it's in the form of blacklists, it's in the form of what further notifications may be there. So let's say tomorrow there is a situation that comes up where in national interest, it is necessary that, Indian data cannot be processed in certain countries, which is a fact. Today we see why. I'm quite certain even citizens will understand why there is a risk in certain nations for data processing to happen. So that kind of flexibility is given under the law, that there can be notification by the board that, these are the certain countries in which these categories of data, let's say financial data, health data, certain categories may not be processed. So I would say that there is no absolute data localization. A very, you could say, nicely toned down, flexible for enabling businesses also to happen till a situation arises that maybe, it's not in national interest that the processing should happen. See, in India, if a large number of people don't understand the concept of enemy state. Now, in all countries, international law also has a concept of enemy state. Now, till there is no situation of war, there is no company which could be considered as an enemy state. But in the situation where there is any form of conflict and war that escalates, then even an organization from that particular country operating in your country is classified as a part of enemy state. So considering that, I do not think this is a data localization as per international law concepts. This is a very standard basic thing I think every nation would have. Because initially when we were talking of physical companies, then in that situation, what would happen? Like, for example, during the World War, if you would be aware about the leading case of a tire manufacturing company, which was a German company, whose operations were restricted in certain parts of Europe. So that was because it was considered an enemy state. The same thing now, let's say if in this digital world we are to see, how much of it is physical that you can restrict? So if a situation of that nature escalates, then in that situation, a large number of operations of different companies are digital, and they are processing data of your citizens. So that can actually pose a considerable risk at some point. So in that situation, I don't see this as, you could say, a throttling form of data localization. I would say a very reasonable restriction of data localization, considering certain geopolitical situations that may not arise. And in those light of situations, it would absolutely make sense to have these restrictions, which for physical businesses are also there under international law. So why not have it when today all your businesses are digital?
Perfect. Makes sense, Puneet. So, Puneet, as a student and, as a practitioner of global cyber policy, cyber laws, privacy regulations, do you still feel that there is something which can, maybe not now, in the next amendment can be added or should be added in the DPDP Act, in the law, which you are seeing everywhere across the world, which is not there?
See, one of the things, this is a very, you could say, common question. Almost everybody on every forum has asked me. There is no concept of an absolute law. Unfortunately, हम अपने आप में बहुत ज़्यादा खामियां निकाल रहे हैं. See, any law which has to remain relevant with the time is going to undergo multiple amendments. You need to understand, if you saw the Indian Penal Code, it remained relevant till date because the definition of theft, murder, and a lot of other major offenses remains the same. It doesn't change with time. When you're talking about different forms of legislation which are pertaining to new age offenses, then there is going to be a transition. Like if you see, we required a new criminal law also to come into place because we were talking of a law which was of an ancient period which has continued for years on it. So if you're going to talk about technology law, like today, for example, you sleep, Ankit, and on your left side of your pillow, and there is a technology XYZ. Tomorrow morning, you're going to wake up. You will have hackers breaching that technology, and you will have companies working on ABC technology. The next morning, wake up on the right side of your pillow. So will there be a law that will be absolute from the time of its inception? My answer is going to be. But what is required is that the legislation is such that it can continue to adapt. The legislative intent is that they continue to go on and on growing the legislation, considering the changes and the time. So it will require multiple amendments. But having something is way better than having nothing. And with respect to a large number of businesses, one of the most important things that they end up asking is, when the board is formed, we need to comply. That's another major, I would say, misnomer, that if the law is already enacted, so that means from the date of enactment, your liability begins. So it's like a simple thing. If a court is not formed with respect to a certain legislation, but the legislation is enacted. So let's say in the period between the court being formed and the legislation being enacted, and if you commit the offense, will you not be held liable for the same? As per principles of jurisprudence, the law is enacted. The liability exists. A complaint can be filed within the duration of 2 or 3 years, which means after the board is formed also. For the prior period that existed, basic principle of jurisprudence states you can be prosecuted. So the law is, I would say, encompassing a lot of factors, even right now. Whether the rules are there, not there, multiple amendments in future are going to be required. If it does not get amended multiple times, I think the law will become redundant at some point. So the nature of businesses is such, the nature of data is such, the nature of technology is such. So I would think this act is a very good baseline from where, as a nation, we need to keep growing based on how we see data being used and misused.
Perfect. So we are at par with all the global laws, regulations which are out there. So it's a
Ankit,
good news.
I think we are better. We are better than even the GDPR. We have a right to nominate where even deceased data is being held of value. So if you realize a large number of cyber crimes that take place, I'm sorry to just interrupt over here, but globally, deceased data is the most misused data, whether it may be in banks, in the insurance sector, in multiple sectors, because there is nobody contesting. So there are fake accounts of deceased being opened. There is money transactions happen. A lot of money mule transactions that are occurring with deceased data. So when the police goes and traces back in different countries, they come to know the person died 10 years back. So deceased data is the most misused data. And here we have a right to nominate with respect to deceased data. So today in your lifetime, you can actually state that this is the person who will determine what will happen to my data after my demise. He can say, I want it erased also. That right is absolutely there. So I would say we are a step better by thinking and respecting what can happen. Imagine the disrespect a deceased person has if tomorrow there is a case registered or an FIR registered against him after his demise because there's a fake account opened in his name in some foreign XYZ country. What kind of a situation is that? So I think we are better, Ankit. We are better. We are on the path of
it was educational. It was educational thing for me as well, Puneet. So I was not aware of that. Thanks for sharing that intel with us. And with this, right, guys, I would and thank you all the panelists for sharing, all this intelligence with us. We are hoping that it gets rolled out soon, and the normal people, the industry, everybody should get benefited from this particular law as soon as possible. Now, I would like to open the forum. I would like to ask the audience if they have any questions for our panelists. We are more than elated to give the responses on that. Any questions, please feel free to ask.
There is an anonymous attendee who has asked a question. You may like to go through that.
Yeah, so I think Sundar Krishnan asked a question. Would some transition period would be provided for stakeholders such as companies to prepare themselves to comply with regulations? Anybody wants to take it up? What kind of a transition period is going to be provided for the companies?
Yeah.
to amend these things? Yeah,
So maybe I can answer this.
sure.
Though, of course, the period will have to be decided by the government, which is yet to be communicated. However, it is most likely to be 18 months from the date of, I'll say, notification of the rules. So reasonable time shall be given to companies to implement it. Of course, it is this time when the board also gets constituted. Its website becomes operational. The SOPs are also in place. So all the institutional framework, governance mechanism to manage, implement, enforce the law are also in place. So reasonable opportunity to companies to be able to comply.
Perfect. So 18-month is the time frame that all of you are going to get.
Should be, and it can be plus minus, because at the end of the day, I mean, it's the government's call, not, but that's my gut feeling.
Perfect. So there's another question, how this bill is going to protect user data, because on the name of job and other application, organizations keep asking all the data, documents, consent on the name of mandatory and internal policy, how we have choice to how we have choice to give which kind of information we want to share or not. Okay, so I think this question is more
Puneet
on
will
the
be
data
most
minimization
suitable.
and purpose limitation. I think Puneet, do you want to take it up?
Well, see, organizations have been collecting data even till date. People never wondered. I'm very
Yeah.
happy that people have started thinking what's happening
Yeah.
about their data. So this was being collected before. All your data was being used everywhere, left, right, center. The fact that the thought has come to your mind today that what's going to happen to my job application data and all of that, which means that something is going in the right direction. You are actually thinking about it. So yes, about this, even organizations, when they're dealing with employment data, dealing with data pertaining to HR, they will have to have the same mechanisms as required for other people's data or customer data that they're processing. So a data principle includes your own employees, it includes your customers, all of them within one ambit of a data principle. So the same, you could say, concept of data minimization, how much required only collect, data processing, cyber security with respect to data security, consent, all of these mechanisms which are required with respect to data principles are the same things which are also applicable for your internal employees. So let's say today an organization says, I am not processing data of any external data principles. So my business model is such that there is no form of data processing of a customer, which is an individual who is Indian. But I have 100 Indian employees. That is way more than enough. You have one Indian employee also. You are going to come within the purview of this act, which means you will require his consent, you will require the entire framework, you will have to follow the basic principles of the act in order to ensure compliance. So when we are talking of data principle, it's not only a data customer or a customer whose data or an individual whom you're providing services or goods to. You are also talking about your man force. You're talking about everybody as a human being associated with your organization, including visitors who might enter your door, and you are at the entrance collecting their data through those all automated mechanisms where you're taking their Aadhaar, their photograph, etc. All of them, if they're Indian, are coming within this purview.
Absolutely. So, now the biggest change that we are going to see is that everything would be driven by the purpose. If there is anything, if the purpose is there to collect your data, it is going to collect it. When the purpose is going to get over, the data is going to be purged. That is what we are going to see. So thank you, Puneet, for your response. There are so many questions now. There's another question. Will the erasure of data guarantees permanent erasure of data in terms of data protection? So anyone wants to take it up?
Technically, eraser means erased. Simple. So which means, as far as the personal part is concerned, so there should not be any identifiable personal information left within the organization, including in the backups, including in the, I'll say, data processors to whom this organization has subcontracted the job, call centers, for example, or maybe data processing for payrolls, or maybe employees data processing being done by external agencies. So everywhere it has to be purged. But as I said, purging does mean that the identification is over. Rest is all non-personal data, analytics of which is like a business issue and must continue, in the overall interest of the economy. And that's what is permitted.
Perfect. Thank you, sir. And guys, we are just about just have 2 minutes. I'll take one more question. Obviously, we'll take a note of all these questions. I'll make sure that all these questions get answered. We'll be sharing the responses with you all. I'll just take one last question. Okay, so there's a question. What about healthcare PHI data? Will it conflict with ABHA, where data will be shared on common platform? Does individual doctor need to take consent? So it's
Maybe here also I can answer.
Yeah, please go ahead.
One, the individual doctor will most likely be out of purview. See, the beauty of this act is that if you are a small player, a small organization, the act is quite lenient on you in terms of whatever consents and all those things are required to be taken. So act imposes proportionate responsibility and accountability on the organizations. Second is about with ABHA, and I'm sure, what is being asked is with respect to, the government coming out with a scheme wherein they are trying to, let's say, I as a patient go to a hospital, but my I'll say diagnosis reports are available with XYZ laboratory, or my previous treatment details are available with the previous hospital. Can this hospital where I have now approached, can it pull the data, or should it be centrally available? Will it be federated data? So yes, it will be a federated data. It will be there where it was supposed to be there, wherever it was created. And on your consent, it can be shared to the organization to whom you have agreed to share. So it's a beautiful architecture wherein, it's something like accounts aggregator in the field of fintech, banking, wherein your data will continue to be where it was. And once, if you don't touch it, maybe after a certain certain date and certain period, it shall automatically be purged as per the policy. But if the data continues to be available, and because patients normally are not aware of what their data had been, so through this ABHA ID, if the person gives the consent, this federated data can be brought centrally for a purpose, and thereafter once again be erased centrally, continues to available wherever it was.
Perfect. Thank you so much, Rakesh sir. Thank you so much, our esteemed panelists, Rajesh sir, Sumnesh sir, and Puneet. It was really nice, discussion, and I'm sure each one of us got something good out of it. So, guys, the bottom line is simple. You are being empowered by two things: right to know the purpose of collection of your data and providing the consent if you want to get processed or not, right? Everything going forward is going to be driven by the purpose and can be done only when you give the consent. So we hope that this thing's roles get rolled out soon, and we all get benefit out of it as soon as possible. So thank you so much for being a good audience. Thank you so much, panelists, for sharing your your experiences and all your thoughts. And we'll make sure that all the questions which you guys have asked will get answered. Till then, have a nice remaining day, and take care of yourself. Thank you. Bye-bye.
Thank you.
Thank you.
Thank
very
you.
much.
Thank you,
Yeah.
Ankit. Well
Thank you, Ankit.
moderated. Thank you very much.
Thank you, sir. Thank you.
Thank
Thank
you.
you, Rakesh ji,
Thank
Rakesh
you.
ji,
Thank you.
Sumnesh.
Yeah,
Thank
thank
you.
you.
Thank you, Puneet ji.
Have a
Thank you.
great weekend ahead.
Thank
Yeah.
you.